Tom?
Thanks. I don't know, I can barely see you. Can you hear me?
Can you see it?
Yeah.
Is there a time delay?
Congratulations just on finding the room. So our game plan here is I'm just going to spend very few minutes laying out the problem statement, and then Richard's going to present the concepts for the triage protocols that we've been working on. So you'll get the concepts in front of you, and then we've asked a couple of our discussants to react to them in front of you and probably with you, we're hoping. Susan and Snorri, one of who is an expert in working with self-represented litigants and the other who's a well-respected court CIO. So we get both the business and the technical perspective, since some of our ideas need technology to implement. So that's the game plan, and then we will reserve time at the end in addition for some interaction with you all and questions and comments. So let me just lay out the problem really quickly at a high level. All of us are familiar with the long-standing and growing issues with self-represented litigants in the courts, and those of you who have been around for more than a few years probably have seen a reaction that I'll most diplomatically think of as either denial or rejection by some members of the court or bench at times. You know, in the early days, there was this hope that the self-represented litigants and the problems that they represented would just go away. But unfortunately, that didn't happen. If anything, the problem grew as courts saw more and more self-represented litigants. And stereotyping a little bit to save time, I mean, I think the next wave of reaction to the problem was on the order of, you know, forming commissions for access to justice and so forth, and basically urging courts to do the right thing, by which was meant providing, you know, support for self-represented litigants. And that's had some moderate success. I mean, we've made progress. Some resources have been made available. There's some good websites out there. And you'll see a lot more detail on those kinds of things at the Court Technology Conference in September. But having said all that, as people tried to do the right thing, resources were scarce, and there are still tremendous gaps between what these people need from courts and from the justice system and what they're getting to be successful in their litigations. And so we've looked at this problem as a resource scarcity problem and asked ourselves, you know, what could we do to do a better job? And part of this started with the realization that people have different capacities as they come to the court, so they have different needs, they need to be handled in different ways. And so we started asking ourselves, how can we improve on this whole situation? Many of you may be familiar with the Self-Represented Litigants Network that Richard runs in partnership with the National Center. And one of the things that the network does is it has a research committee that looks into different kinds of issues related to self-represented litigants. And we were meeting one day and talking about this problem, and the question was raised, what do court experts use as their kind of decision rules for triaging or deciding which kinds of assistance self-represented litigants should get and how they would be handled in the court as their cases go forward. And as we talked about this more and more with the expert, the distressing response that we got back was most of the time one of two answers. Either the self-represented litigants just got whatever resources were available at the court, so what they had was what they got, or they used basically an intuitive approach where the expert just kind of, you know, based on their experience, tried to decide what the best way to help them would be without any really rigorous or evidence-based approach. Well, we thought that needed to be improved upon, so our project was to come up with these more explicit protocols for how you would provide assistance to self-represented litigants, and hopefully that would use resources that are scarce more efficiently, and everyone would benefit from that. So that was the problem we were trying to solve, and so Richard's going to talk now in detail about how we tried to go about doing this.
Thank you. We pulled together
a group of, as Tom says, experts, and what we realized, and we spent three very exciting days teasing out, really developing model protocols. And I think the first thing we realized is that there are three different kinds of triage going on. The first is the self-triage done by a litigant in deciding what they want and how they want to proceed. And the second is, what does the court, how does the court treat this case, reflecting the choices already made by litigants? And the third is, to the extent that there are helping organizations outside the court, like legal aid programs, how do they decide which cases are going to get assistance and of what kind? And we then realized, and this is based in part, by the way, on some of the work in the Civil Gideon movement, that when you try and tease out, excuse me, I'm going to take out this candy, it's a mistake. Building on what Tom said, the problem is that the kind of things that make a difference in terms of how you can most efficiently and most accessibly, and in terms of getting the fairest result, the kind of factors are actually very, very different. Traditionally, courts have tracked by case type, and Tom pointed this out, and really nothing else. Legal aid programs have tracked based on first come, first served within a limited list of priorities. And so when you step back from this and think a little, and talking to people who ran self-help centers was really important, because as Tom said, a lot of it's intuitive, but intuitively describable, right? People could actually start to talk about what they did, even if it wasn't regularized. Case type is obviously important. Case facts and complexity are obviously important, because it's obvious. An eviction that deals only with whether or not the check was delivered or not is completely different from a custody dispute involving claims of domestic violence, kidnapping, and so on. It is also entirely different from a landlord-tenant case involving complex claims of violation of warranty of habitability, retaliation, etc. The third, and this is the one that I think the Civil Gideon people really brought to the table, is oppositional situation. What's going to be needed to manage the case appropriately is completely different when you are against a housing authority than against a self-represented landlord. And it's going to be completely different, obviously, in family law when the husband and the wife basically agreed on everything, versus a situation where there is domestic violence and fear and huge imbalance of power. So that tends to break down into, oppositional tends to break down into two or three things. Whether you have the government on the other side, regardless of who's providing representation, whether or not the other side is represented, and the personality type, shall we say, for want of a better phrase. Another factor, and this is the one that is really largely ignored in most systems, except intuitively in some self-help centers, and I'm sure at some clerks' front desks with humane clerks, is litigant capacity. A comprehensive analysis would really ask, what are the tasks that have to be performed as a result of those three first bullets, and with what kind of support can the litigant perform those tasks, right, with the capacity we've described in the fourth bullet. And then the fifth one is, well, what tracks are actually available? What paths are actually available? What services are actually available? That's it's obvious, but it's also subtle. The obvious point is you can't track somebody into something if there isn't that service. But the more subtle point is that when someone's in a particular service under one of the protocols, what are the implications for how the other protocols play out? And indeed, and I'm sorry to be a bit theoretical, I'm going to give you some practical stuff in a second. One of the huge problems with this is the circularity of all of this, right? If a court decides to put case into what is traditionally and unfortunately called in family law high conflict, and I call something different, that impacts what the litigants' choices are, and certainly the extent of the kind of help they're going to need in navigating that system. Let me just explain why I don't like the phrase high conflict, because the phrase high conflict suggests that both parties are equal to blame in the creation of the conflict. And that may well be the case in some situations, and it may well be that you have to start with that assumption, but ultimately you find out it's not true, right? And and obviously domestic violence is a situation. And all the research says that when courts are very firm with the party that's causing the high conflict and holds them responsible for the consequences of that behavior, the behavior changes. If, on the other hand, you shift the goalposts every time somebody doesn't comply, they have no incentive to comply. So teasing out which of these do you decide first and what's the impact on the others is not easy and will vary depending on the kind of case as to what is, or can vary, depending on what's driving it. So the model now is somewhat of a dynamic process, understanding that when something changes in terms of one of the protocols, then that has implications on the other protocols, and that's so a legal aid program would need, for example, a monitoring system so that when a case moves into a high attention mode, then they may have to also provide it high attention. Now, this is all great, right? Here is our sort of assumption that we have a protocol system. We give people, for efficiency, the minimum necessary for them to obtain access to justice. That's the core concept, right? That's all great. But what happens if your total resources aren't enough to give everyone what they need for access to justice? My own view is that the reason all of us have done such a lousy job of focusing on this issue of protocols is we have been scared about facing that fact. If you have protocols that say, in the following circumstances, somebody has to be given the following kind of services in the court and has to have a lawyer, and you can't do either, it's very, very clear. And the institution is essentially failing. It's one thing to make the general statement about how much more money we need to do a proper job and how many cases we have. It's very different to get to the point where you know internally which cases you've let down, right? What are the appellate implications of that, right? So I think we've tended to be scared away, and that means we can't quantify, and that means we can't get the funding, and we can't solve the problem. So in that sense, this attempt to develop triage really is an attempt to break out of that catch-22. And we need to, obviously, to track and report. But what we've also come up with, and there are two different points here, the first and the third. The first is that the concept of adjustable protocols. Let's say that we have decided in a particular category of cases that if litigants don't have capacity, then they get an attorney. Sufficient capacity. Obviously, sufficient capacity is a little bit of a sliding concept. So you settle on a score or an approach or an assessment that says where that cutoff is. But you also build it dynamically so that the resource just isn't there. You have to start denying to people who ideally would get it. But the point is to be intentional and consistent about that and have it on some kind of numerical or at least triggering system so that you're rational rather than just doing it at random, which is the way we tend to do it. And then the other point, and this one cannot be hammered home too much, which is that you can save resources in one of these protocol systems by changes in the underlying system that other protocols serve. What do I mean by that? If the judge makes no effort to engage self-represented litigants, and I hope no one's from a court where that happens anymore, but I don't live in a fantasy world, right? Then you have to put more resources into counsel and more resources into self-help and explaining afterwards what the judge has done and so on. If you retrain your judiciary, then you start saving resources in other places. So all of these things are dynamic and moving around. It's not like we can just write a draft protocol which we then just freeze and put into place in every court in the country. They all change, and every court is obviously different. So, I thought it would... Any questions or thoughts so far? Okay, except for why is this guy so theoretical? Okay, now to the practical. I'm going to walk you through the outline of 3 protocols we developed in family law. And the first one, as I say, the order can move. It seems to start with the question of what the litigant want, move on to the question of how does the court track it, and then move on usually to how do nonprofits support people in that process. As we know, the family law is largely a self-represented litigant operation these days. And one of the things we realized, and this was really one of the most interesting parts of the discussion at the planning meeting, at the design meeting that we had, was that we really paid no attention to making sure that litigants go into this system having made choices reflecting what they really want. So this is actually quite sophisticated. The first thing is what we call the decision planner, right? And here we ask the litigant what they want, as in, do you want custody? Do you want partial custody? Do you want visitation? How much child support? And asks enough questions to enable the system to show the statistical likelihood of their obtaining those outcomes. So this is a reasonableness test. If the litigant, in effect, is asking for something other than what is reasonably likely outcome, given the facts that have been collected, and obviously deciding what those facts are is a complicated design question, but people in the field know what they are. Then they're asked, why are you asking, is there any particular reason you're asking for sole custody? Given that, in fact, in this court, 95% of cases end up with joint custody. And based on that answer, additional data might well be found. If there's domestic violence, has there been a police report, has there been injury, have you had a protective order, etc., right? And then it basically goes through a second prediction, and I guess you could go through other iterations, and then it asks the litigant what they want to do. This concept could apply in any kind of case. I mean, in the landlord-tenant case, do you want whether or not to fight the eviction is going to depend on, how much you need to stay, right? What kind of defenses you have, what the state of the law is governing those defenses, which seem to vary hugely state by state. We were really astonished to find out, and so on. So that's that concept. Now, so at the end of and obviously in some kinds of litigation, they're going to be very different models for the plaintiff and the defendant. For example, the question of what a landlord wants and what a tenant wants are very, very different. The question about what a father wants and what a mother wants essentially are the same protocols, right? In the eviction one, does the landlord, really the first question is, does the landlord really want the eviction, right? Is this a collection mechanism, or is this a getting the house free so I can build a 40-story tower, right? Now, there are all kind of questions about the extent to which we're actually going to be able to get that information from people, right? And the question is, are these confidential systems? Hopefully, and so on. So any thoughts or questions on, or improvements to this protocol? Sure.
I'm wondering, as you're going through this protocol, at what point you would provide information? So you're seeing data at step 3. Is that also where you might provide information that the litigant doesn't know?
Yeah, I mean, absolutely. I would think, I mean, yes, thank you. That's very, very helpful. All the way through is my short answer. I mean, I think that, although I think there are particular decision points where, a lot of, obviously there is already information online about, how you bring the litigation and so on. What's not online is how much work is it going to take, how much is it going to cost, all of those kind of things. And, what we're trying to do, and your point's really helpful, what we're trying to do is have litigants make really informed choices. Hopefully this will reduce, but only appropriately reduce, the flow of litigation, right? If people make informed choices not to litigate, that's good. If they're going to lose anyway, or they're not going to get what they want, why should we waste all the court's resources? And obviously, this envisions essentially a technological system. It could be done one-on-one, but it's going to be much safer. It's going to be have much less inappropriate discretion in it if it's done technologically. Okay, now, what we then thought about was in family, we thought about 4 tracks. And obviously you can play with this, and different people in the group, actually we really argued about whether it's 2 tracks or 4 tracks and so on. But the formalization track is the track where all they're looking for is the stamp, right? Real question whether that should be in the court system at all, whether you should just be able to mail it in, right? And then the second track is the detailed finalization track, which is where, pretty much everything's there, but they haven't quite figured out how to split the car, or they haven't thought about they have to figure out how to split the car. New Hampshire, for example, those kind of cases are sent to I think they're actually sent to somebody who's nominally designated a case flow manager, who sits with the 2 parties and says, what do you do about this? I'm going to do about this. And they say like this, and she or he says, well, what a lot of people is, and they both nod, right? And that's that. That's 20 minutes, right? Well, think about if you had to do that in the courtroom, right? The third one is the way we think about the system, which is the typical decision-making situation. Both parents want custody. They're both good people, or at least they're both behaving relatively fairly with each other in the system. It's not the best time in their lives. They're not perfect, right? But they also want someone. I think we tend to underestimate the extent to which parties, in particularly family law cases, want someone to tell them what the right thing is. They want to feel they've sort of stood up for their kid, and if they said they weren't interested in their kid, that would be showing they didn't love the kid. They want someone to just say this is what's right. So it's a relatively straightforward, simple process, right? But, also can be complicated because of the kind of factors and the kind of evidence and so on. And then this, what I at least prefer to call the intensive attention track. And they are the tracks that, already get the intention whether they want it or not, but they tend to be on the same calendars, they tend to have the same judges, the same services, and they clog up depending how many of others are still on the same track. And so then the question becomes, how do you track them, right? So here's the proposal, which would be identify the cases that are almost ready from the litigant positions. Presumably, again, it's technology, so they've done the forms electronically, you just match them. And then you identify the intensive attention track from the positions in the paperwork and from the files. You could literally weigh the file, right? And so what you've done is, out of the 4, the top 2 have gone off this way, the bottom one's gone off this way, and you're left with what I don't say statistically is the default track, but analytically is the default track. And then, so we haven't here worked out what kind of services you would provide, and that would obviously vary with what the court did and so on. And then litigant services, that's the third protocol, that's what's legal aid going to do. Well, so sort of you go to the you're now sent to the legal aid portal, or perhaps you walk into the legal aid office, or you're on the phone from a church or something. And if you're in those top 2 tracks, all you get is self-help services, might be provided in the court, actually might be provided by legal aid, unless there's an attorney on the other side. Because if there's an attorney on the other side, then you need a little more, because you can't really trust that attorney to not overreach. The decision track, which is, as I said, the sort of our standard evolved, that gets the unbundled interview and presumptive ongoing unbundled assistance, especially if there's complex discovery. But the unbundled interview could result in a decision that this person, they're set. I've told them what to do, they're set. But that's unlikely where there's complex discovery. If the decision track has, the litigant has low mental, well, I'm going to use the word capacity in general. We're thinking obviously specifically about mental capacity. It includes educational level, prior experience with the system, and so on. They get a full attorney. Okay. They would not get a full attorney, remember, in formalization and finalization. The intensive track presumptively gets counsel, right? And you've got to do a diagnostic interview to figure out in those cases where there are exactly what they get. So any questions or thoughts on this part of the presentation or on the yeah? We don't know. I mean, this is not something that's running now. I think that a lot's going to depend on how well we can use technology, and what kind of data. Part of what we're going to be doing is we need to be doing, I should say, is we're going to be figuring out how much data you need to collect to have a reliable answer to these kind of questions, and where you collect it from, which leads perfectly to the next slide, because. What's the data? Well, there are really, these next 2 slides are sort of overlap, but there's an algorithm process going on here. In other words, a formula is being applied to something. Well, where's the data pulled? It's pulled, let me show you the next slide as well. It's pulled from court files, interviews. Interviews would include online interviews or human interviews, and other agency computer systems. And I think this is obviously the most controversial part of it, but also the most potentially breakthrough part of it. So issues like assets, income, well, not so much assets, income, experience with other parts of the bureaucracy, court history, there's a whole bunch of stuff that's available that helps figure out how to process a case. Building these links is, in some ways really the task for the future. And figuring out the kind of confidentiality protections you have to have in place in order, is this with consent? Is this a condition? What's it a condition of? How do we keep those promises when the NSA has it all anyway? So what are the lessons from this whole design? And the first is really a repetition. The first is the idea that what the triage looks like and what the services cost really depends on what the underlying court processes are. We spend a lot of time in the planning sessions sort of arguing about whether or not we were going to change the court processes as a result of this protocol system or not. And I think we ended up not talking about not building, and then the problem was, how do you do a protocol system when you don't know what the court system looks like? And the result has been we've stayed at somewhat of a level of generality, but we are convinced that what these protocols do will drive a discussion about the underlying court processes and how to simplify them and make them cheaper and more accessible and more effective. The other thing that happened as we worked through all the 3 types of protocols in 4 different areas, we did in family, eviction, credit card, consumer debt, and foreclosure, was that there are critical needs for well, let's put it this way, that people needed help, when the courts needed help, in dealing with various of these situations, and the right level of skill, capacity, and expense didn't exist. And as an example of that, we found again and again that we would be saying, well, in this area you want unbundled. You want the person to get assistance but not full assistance. And it highlighted the extent to which our unbundled delivery system is still not anything like as comprehensive as it should be, and that the courts are far from having really fully figured out how to realize the potential benefits of that and figured out what role to play in spreading it around. And then, as many of you know, and I've blogged about it quite a bit, there's really a movement starting to really try and look at non-lawyer practice. And several states have processes moving forward, including California and New York. And there are situations, for example, let me give you an example. In the foreclosure area, there's a step in the process when you really want to figure out whether you have a defense or not. And they are very complicated, technical defenses. But they're not something you need to had 3 years of law school to apply if you've been taught them. They're just complicated flowcharts, right? Is this amount greater than this? Does it apply in this? Right? Has the person said this? Has the bank given you a notice with this language in it? And you've got to know which document to look at. So to quote Chief Judge Jonathan Lippman of New York, sometimes an expert non-lawyer is better than a lawyer non-expert. And we found a lot of those situations. And so we think that unbundling and this non-lawyer practice thing are going to be that the triage process highlights the extent to which we're only going to get 100% access to justice by bundling those in. And then the other lesson is that data has to move between institutions, and that there are all kind of complex policy things about that. But in terms of making this process bearably efficient, it's critical. And there's no reason we can't solve those problems the NSA has. Yeah.
I don't disagree with what you say about expert non-lawyer being often better than a non-expert lawyer. But as I understand your model, you're having a court personnel advise a client, advise a person as the chances of their getting the outcome they seek.
Well, I'm probably having the computer do it. Having the computer apply an algorithm rather than an individual.
But it's something that comes from the court.
Yeah.
And my concern is that is going to feed dissatisfaction with the process and the feeling that they have not had an opportunity to be heard. For every individual client I ever had in practice, their case to them was absolutely unique, although it may have fit a statistical norm to a T.
Right.
But to them it was unique. They would not be satisfied unless they felt that people had actually heard their particular story. So when you have an attorney providing that input from outside the court system, providing that input, that's one thing. But when you have the court saying it, before the person has had an opportunity to come into court, they're going to feel that this is predetermined, the judge's mind was made up, there was never any chance for them to get the result that they want. And my concern is, in the long term, are we reducing the credibility of the justice product by the court saying in advance of any sort of hearing, this is the outcome of your case.
Well, I think it depends on a couple of factors. I mean,
Can you repeat the question?
the concern is that the court, by even through a computer predicting outcome, will be perceived as the court not being responsive to individual concerns, but everything being predetermined. And I mean, of course, this is the tension in the legal system between predictability and discretion, right, is like a constant tension expressed in a million different ways, the federal sentencing guidelines and everything. This is not a new problem. I think a lot depends on I mean, it's an very useful point. A lot depends on the wording. A lot depends on the substantive issue, right? In other words, when a state has child support guidelines, they've been predetermined by the legislature, right? Or by a commission or something. And, I've certainly seen judges and, judges, when litigants get upset with results, judges are very good at saying, look, it's not my choice, right? This is the guideline. If you think there's something that takes you out of the guideline, let me know, and that was meant to be up there. So I think, but it's certainly an appropriate concern. Thank you. I think that may be the end of my... Yes, it is. Great, perfect, thank you.
All right, so you've heard the basic ideas, and that the project that Richard keeps referring to, where we tried to work out some draft protocols for 4 case types: evictions, foreclosures, credit card debt, and divorces, was funded by the State Justice Institute, SJI. So I don't see Jonathan here, but we really appreciated that funding to take a shot at this. I've got 2 people on the panel up here who are going to react to Richard's ideas and hopefully react with you to those ideas. First of all, we're going to have Susan Ledre from the Minnesota courts react. And Susan participated in this project with Richard and I, so she was right at the table as we were trying to hash these things out. Snorri's at a little more of a disadvantage, Snorri Ogata from Orange County, California Superior Court, CIO there, because he was not at the meeting. But after the meeting, as we search for victims, I mean, people willing to try these things in real life, he works with Alan Carlson, who's sitting over here in the corner of the room, and I don't think Alan and Snorri have ever said no to a request from me to try something new. These guys are real risk takers. And so they're working on a small claims pilot now that tries to implement these ideas. So Snorri will have some interesting comments about that as well. So Susan, why don't you tell us what you think about all this?
Good morning. Just a bit of introduction on who I am. I'm Susan, and I'm from Minnesota, and I work in the Hennepin County District Court, which is a large urban court there, and I manage the self-help programs. I also spend some time on the bench in housing court. I've also been a pro se litigant, so from that regard, I think I'm qualified to comment on that pro se party making their choice. I'm a lawyer, so I've represented people working in self-help, and then the bench perspective. But I will say, I think this is the hardest presentation I've ever done, trying to react to this topic and concept. I guess my first comment would be with regard to Tom's introduction, which was how he talked about the whole situation, which is very traditionally, there's this problem. These people are a problem. We have to try to deal with them. My reaction to that is I'd like to see us put that in the past and start talking about this differently. We, as court managers, are dealing with the reality, whatever that reality is. Our reality changes all the time. There may be some major new legislation that changes how the court needs to operate. We may have budget problems, or we may have new money and opportunities to do things. We may have demographic changes in our communities with more elderly people or immigrants moving in, and that's just all part of the reality that we need to manage to, and more self-represented litigants is part of that. So I would just suggest that we start talking about what is our mission and our vision of our court, which is access to justice and fair resolution of cases, and then how does this fit with it. So that's my first observation. Second observation is, I think this really takes a big picture approach. It's really looking at a problem as an entire system. And that would be one area where sometimes the courts do that very successfully, and perhaps more in the criminal justice area. I think we're more used to looking at things systemically when it comes to criminal matters than we have perhaps in family or civil or other areas of the court. So really we're talking about figuring out what services are out there in the community, who's providing legal assistance or moderate means type of legal services now, what are their priorities, how are they deciding what they're going to do, and how do we engage them in this process, because this assumes that there is some help out there for people. And if we're going to try to come up with a big picture solution and use data and use analysis, we want to be able to direct or influence those decisions that are being made by legal aid or other organizations that are providing services. So obviously we have to figure out how we're going to have a close working relationship with them. And how many of you in the room feel that your court has a really meaningful, close working relationship with legal services or the bar, so that you really understand where are they coming from, what's driving their decision making, and where you feel like you could really partner with them? Just by show of hands, how many of you feel you have that kind of relationship? It's quite a few. That's great. So from the standpoint of would it be realistic to be figuring out a big picture solution like this? Do you think that's something you could do within your communities? Anybody have any comment on that, or have you done that successfully? Yes?
I think the organized violence is very difficult. What's been proposed, certainly the whole concept of non-lawyer advocates flies in the face of, at least in my experience, the bar think this is the way to go. And when the bars in Massachusetts have successfully sued these companies that have been called practicing law without license, and have won appellate cases in Massachusetts to stop the practice. I think those of us in the court system and the organized bar have a real difficult concept with that. And the question is, who's responsible for building, implementing, maintaining these protocols? Courts to maintain its unbiased standard. I'm not too sure the court will.
Okay. So did everybody hear that? Okay, so if I could summarize. Oh, do we have a mic that we can pass around? Okay, thank you. If there are going to be non-lawyer advocates or advisors, that could be seriously become a serious concern of the Bar Association, and that they might object or fight this. And then asking who would prepare these materials and who would be responsible for that. Would it be the court or would it be someone else? And that's problematic. Really, a lot of this seems to be trying to figure out, it reminds me of Roger Hall's speech this morning, his presentation about how do you get what's in somebody's head. Because a lot of this is, if you were to sit down with the litigant and diagnose for them, you know, what is your situation as a lawyer if you were doing this? What are your goals? How would you get there? You're really talking, Richard, about putting that into a technology solution so that you're building a logic somehow, and maybe Snorri can tell us if this is something that's easy to do or would be very challenging, but I think it really ties into Roger's comments about needing to figure out the thought process is in somebody's head, and interviewing them about that and trying to get that information. And then I share the concern of the first person who spoke here about not seeming to give an absolute outcome or a prediction that would turn somebody off. So that there would have to be some real careful handling of that between what is hard and fast law or what would be helpful information, and then perhaps bringing in the bar or the attorneys in your area to say, this is a point where you should now get legal advice. I think it'd be really important to bring that into the front end, the diagnosis stage, that litigant decision making. And I don't think it's the intention of the protocols that they would be excluded from that. But to me, it seems like a combination of some technological thought process plus the ability to talk to live people who can help you analyze that would be very important. We often refer to our legal advice clinics that we have at the courthouse as providing a reality check for people, because we do feel very uncomfortable as court personnel saying you just shouldn't go forward with that. You don't have a chance, or that's frivolous. We just can't do that. And I've had people turn around and say, you're telling me I can't file. You're denying me access to the court. So you really do have to be careful about that. And that's where having legal advice available at the courthouse, as we do in my court, is very helpful, because we send them in to talk to the attorney who says, you're crazy, don't do this, you're going to get slapped with, fines and fees and everything else. So there is a role for both of those, I think. It's a big challenge to think, too, about where does the data come from, and it'd be interesting to have time to get into that a bit more to inform some of this decision making. Another kind of observation I have is we tend to do a lot of case management now, and I'm sure all of you do. So when Richard talks about the different approaches, differentiating cases, is it basically a default? Does it need a little bit of help? I think we probably all do those kinds of things. And then, we also, at least in Minnesota, involve the legal community, and they often will come to the court and say, how can we help? What do you need? What can we do on a pro bono basis to help? And I think the difference here is this envisions looking at something from beginning to end and saying what's the optimal to get from beginning to end, where what I tend to see in my court is the court does things a certain way, and we look for help from the bar or from legal services to fit into what we're already doing. So we're not necessarily really open to the idea of changing what we do. And that's where I think it's hard for the bar to come in and say to the court, well, really you should fundamentally change how you're doing this. You shouldn't just be continuing to do what you do and asking us to help you, because oftentimes the court's goal is to get these cases done with as little court time as possible, which may not mean it's the fairest and best outcome or the best access for the public. So that to me would be potentially a shift in how courts would have to look at this or partner in order to implement some kind of a solution like this. So that's all I'm going to say, but does anyone else have any reactions they would want to share from the court manager perspective before Snorri talks about technology? Okay, thank you. Oh, yeah.
Thinking about the question about the lawyers, I guess that's a lawyer culture issue like we have court culture issues. Our sense from our county is a lot that even the family law lawyers know that they're never going to get clients out of this group of people. They're not going to get paid by these people, so they don't have a problem with us helping them at some kind of levels. And we have some of the same kind of things Susan's talking about, where you have lawyers that come and sit and people can go talk to them on limited kinds of things, it sounds like. I don't know whether your lawyers have a sense of what you're doing, or you can co-opt them by inviting them in to be part of what you're doing. But the unauthorized practice of law issue is a problem. I mean, they think we're doing it as the court, I think sometimes. Do you have a sense of what it is that's causing the lawyers to feel that way at all in Massachusetts? Greed, is that what you said? Yeah.
I mean, we have lawyer of the day programs that we partner with the bar with. Massachusetts now has LAR, limited assistance representation. So the Supreme Court has approved the complete unbundling of all legal services. We've had attorneys that, in the year and a half that we've had that program, have made a very good private practice out of that. They simply do one particular aspect of a particular case, and they do it in such volume and at such a reasonable price that it's working for them. But the bar hasn't even stepped up and embraced that concept, in my mind, fully. But there's a formal bar association called REBA, the Real Estate Bar Association. They're the ones that have been very active in filing suit against these individuals, mostly in the financing and the foreclosure area, bringing these types of actions. And anytime we meet with the bar, they're very concerned about non-lawyer advocates now having a place in the courthouse, because that appears that the court has given its blessing to these programs. They just think that I'm sure it's part of the conservative legal culture, but that they just raise that objection on a regular basis.
Can I speak to that issue? I mean, I think the culture is changing very fast about that issue. You know, a couple of months ago, there was a gathering at the White House on access to justice. People know Joe Biden was once a public defender. He told us about it. And so as part of the presentation, actually part of the presentation on pro bono, Martha Minow, who's Dean of Harvard Law and Vice Chair of the Board of LSC, asked the president, incoming president of the ABA, asked Jonathan Lippman, Chief Judge Jonathan Lippman, about about this non-lawyer practice, and he gave a very convincing argument that basically something has to be done, and this has to be part of the solution. And he's a very forceful chief. And then she turned to the incoming president of the ABA. What did you think about this? And she gave a basically positive, sort of really 2 points. Something's got to be done, and we certainly rely on lawyers to do a lot of things already. So I think that the signaling from the top of the system is very clear that we have to move in that direction. Obviously it's going to be dependent on politics, but one thing you always remember is when a court says you can do it, you can hardly say it's unauthorized, right? And I also think that we've started to do this in New York, when you actually start to look at the case law and even the statutes, it's less clear than you'd think about where these lines get drawn. There is, for example, there are two leading cases in New York in 1919 on this issue. One case finding the unauthorized and one not. In the one finding not, the writing judge says something along the lines of course there are limits to this principle of keeping things in the hands of the bar. A person may complete their own form and plead their own case and perhaps get help from a friend or neighbor in doing so. Right? So, there's a little more slip than we think.
I think I'm Richard Schauffer from the National Center. A complementary SJI-funded project to this one is we are scheduled to complete at the end of September, which is to define a standardized way of counting these cases and of trying to report that information out of case management systems. And the part of it that I think is complementary and that would facilitate this dialogue in the courts is what systems currently, the best systems are currently capable of doing is accumulating the history of representation status by event over the life of the case. So you would know by case types from filing to disposition and beyond. Did the person have representation or were they self-represented? So that would allow us to have a conversation about this that would be informed by this kind of data so that you could see, A, what's the extent of the problem or the issue? B, where do people who are self-represented choose to acquire unbundled legal services, and are they making that decision at, you might say, the optimum point, given scarce dollars? Is that the right place? Would a model predict that's the more complicated part, or are they making a decision there just because of fear or bad information or something? So it would help them make better choices. And I think it would help facilitate this conversation, because I think part of the problem in the courts right now, we can cite case law all day long, but that it doesn't help advance the conversation from a justice point of view in some level, and from a court management perspective, which is how big of an issue is this, where is it an issue, at what stage of the cases is this an issue, and what could we do to focus this, because that might help open minds about where these tools then become most relevant and what kind of problems they could solve.
Bonnie?
I'm Bonnie Huff from California, and one of the things I think is that we need to build these systems so that they fit in with, that they really support the court in terms of how they manage. So I personally think that with family law, the court really does already do a fair amount of triage. As we're moving into more case management, we are assessing cases as they move along. And I think, you know, information will continually feed in. Did the person manage to complete service? Is there a default in a timely manner? Are those different kinds of things? And then you keep assessing the file, and hopefully you're doing it in an electronic way, so you don't have clerks having to manage and pull it. But you're looking at a case all the way along, because in family law, it can change, right? A case that looks like it's uncontested at the beginning can shift and vice versa. So I think the more that we can build the system so it's built into the regular operations of the court, I think will be the most helpful. And one of the things, we have a pilot program in California that's providing representation in high conflict custody cases and trying to assess, if you put resources into that at the very beginning of the case, can we get it? It looks like in one of our courts we're getting those cases settled really quickly and in a way that seems to be positive. And so we're going to be going back and saying, but do they stay settled, right? What happens ultimately? But, you know, I guess I think that we should be very mindful that this should be supporting the court in what it already does and, you know, helping to get, and I do think that technology might work for those people who really anticipate the divorce being pretty straightforward, who want to do it using automated forms, all that kind of stuff, just want some basic information. I think they will really be assisted by that. And then, you know, other folks will need additional, probably in-person, you know, assistance from the bar, assistance from court self-help, other kinds of services. But I think that there's a growing population of people who would be thrilled to have a technological solution to say, you know, this is an easy divorce, I can fill out these papers and just get it done. And that would be great, because that would, you know, handle those folks very effectively.
Anything else? All right.
So historically, technologists' response to self-help and triage is just build a website. So lots of courts have, you know, websites, and we think we're done, right? Because every piece of information you could possibly need, you know, is available out on that website. So we built these rich information sites, impossible to navigate, not very intuitive. And then at our court in particular, we started to re-examine, how effective are we in doing this. And so, Bonnie touched on something that I thought was interesting. In Orange County, somewhere around 2009 or 10, I think, we reorganized self-help underneath operations, court operations. So it had been historically a standalone unit up on the side because it presumably, extended beyond court operations. When we made the reorganization and put it underneath operations, our mindset and attitude towards self-help actually changed, right? It was how can we leverage this capability and set of services in a way that'll drive efficiencies into our court. And we're a pretty tech-aggressive court, so of course we immediately started building, websites and new applications. So we tried in a couple of areas in a partnership with Legal Aid Society through a system called ICANN, which is document assembly, right? Answer some, questions ultimately for the point of filling out the form, right, and getting the information in. But then you start to realize that, well, that's sort of late in the process, right? That's not where triage is, right? Triage is actually much earlier when you're sort of trying to help them diagnose, do they even need to file a case? Is the court the right place to actually resolve this? So over time, we've started to experiment with, some different technologies. The current one that we're playing with right now is a really cheap little tool called Pubble. I would encourage you to give it a try. We're about 3 months into our experiment with it, and it's just an augmentation to your website of sort of frequently asked questions. But there's an interactive component to it. So if they don't see the answer to their question right there, they can submit a question, and it inquires against a database and says, okay, here are 3 questions previously submitted that look similar to yours. Does this answer your question? If yes, then you're done, and you've moved on to the next step. Right? If not, you can submit a question, and our court has taken the step of actually dedicating a portion of one person to responding to these questions that come in the belief that there is a finite number of questions that can be asked, and over a period of time we're going to actually capture them all, right? And we'll build that knowledge base. So Pubble, P-U-B-B-L-E, and it's a technology that's working really well in university settings, right? So think of I'm applying to a college, or I've just been admitted to a college, and now I have all of these questions about how do I get my roommate assignment, how do I register, where do I get my classes, and so it was very, very successful in that context, and so we've been trying to experiment with it a little bit in the court context, and I think it's going to be positive. So from a pure tech perspective, though, with respect to Richard's point on data, technologists like standards, right? That's sort of the first thing that we like. It provides some safety and comfort for us, right? It's our crutch. But we also like to build things. And when we like to build things, we need a couple of things to really be successful. We need requirements, and unfortunately, as all of you can attest, you probably all speak a different language than your technologists. I think Jorge and I might be the only 2 technologists in this room. And so you have to figure out ways to bridge that, right? So self-help people speak a really different language, right? It's very impassioned and principled and noble and God's work and, advocate and all this, and our technologists are like, well, we just need a logic tree, right? How does this relate to that so that we can write a piece of code that will, that will do something? And so we've attempted to bridge this gap by inviting a business analyst. So we actually took someone that was formerly in HR training in our court, gave them rudimentary training in being a systems analyst, right, learning how to do simple flow charting and process mapping and things like that. And then we invited Tom and Richard to come out and give us a quick education on what this whole triage thing was about. And we said, okay, well, let's give it a try. They asked us to give it a try. Alan said, sure, this sounds like a lot of fun, so let's go. So one of my curses is that I actually think in PowerPoint. So as I was organizing my thoughts this morning, and I told them that I wasn't going to have any slides to share, but as I was organizing my thoughts this morning, I said, well, let me just start writing notes down here so that I can think of it. And not surprisingly, because Richard and Tom came out and talked to our court and the 5 Southern California courts, the language is similar, right? Because we were trying to solve this triage thing, and we're trying to apply these principles and protocols that are being developed. So we've been working as a consortium with the 5 Southern California courts. So that's Los Angeles, Orange County, San Diego, Riverside, San Bernardino, Imperial, and then somehow Santa Clara Superior Court found out that we were doing something, and they're like 300 miles away, and decided that they were part of Southern California. I can understand why Northern California would want to associate with Southern California. But if you put us 5 courts together, just in Southern California proper, we're actually the 3rd largest state, I think, right between Texas and New York or something like that, just in terms of the volume of the population that's there. And so we caucused this group together. We invited Bonnie and the AOC folks to come down. They sent representation down to say, okay, let's look at this triage thing from sort of a different perspective and see where we get to. And we came into sort of 5 modules. Again, now I'm going to talk in tech speak, right? So we view the world in sort of discrete buckets or functionality, right? So you have this notion of these protocols that Richard has, the litigation model. How do you get the person to the right resources? How do we get them lined up with the right court, function? How do we get some information about the litigant to build a relationship with them to enhance the services? How do we educate them if they're at the point where they need education? How do we direct them to either court resources and potentially maybe even non-court resources? And then what other sort of steps do we need to go? So from a litigant user model, the purpose was really to determine the litigant's level of comfort with unfamiliar information in computers, right? So a simple prompt question, right? And what we're doing as a court is we decided that because we like standards and because the New York State court system is doing some really cool things with A to J author, we said, okay, this looks like the tool that seems to be getting some traction. The Legal Services Corporation said we really want to promote, A to J as one of the standards that are going to be used in this area. So we're going to try it out. We've never done anything with A to J, but we'll give it a try. So this could potentially be, the first prompt question that comes up there, right? You can use this website in many ways, from do-it-yourself, et cetera. I'm not going to read it all, right? But the point is that we want to help users sort of self-identify themselves in, you know what, I'm confident I can go do it all on my own. I don't need any assistance, right? We have a lot of those. I want some help, take me on a guided journey. Or you know what, I really need help, right? So I think this was one of Richard's protocols. Redirect me over to a legal aid entity. So in Orange County, it's not all the Southern California counties, but in Orange County, our small claims advisor is the Legal Aid Society of Orange County. So we would just redirect them over there. From a jurisdiction standpoint, we've been playing with some visualization techniques. I only did a little cut of a screen just so that I would remember what I was talking about. But it could be before you jump in, so you've identified yourself in one of these categories, but before you take you to the next step, let's get just a little bit more information from you in non-court speak so that we can help direct you to the, this thing really is small claims, or, oh, wait, this is family, it needs to go down this path, or maybe it's, something else. So the idea here is to, in a non-court organization linear structure, direct people into our flows. Getting litigant information is actually the big aha for me as a technologist. The complaint that kept coming up over and over again was that people, as they're moving through the process, enter the same information a bazillion times into a multitude of systems. And a technologist, it's simple. You stand up a little website, gather a little data about a person, and you're good, right? You've captured the information. But when you start to think of triaging and relationship building with somebody, your paradigm shift, occurs. And so we're really, in Orange County in particular, but Riverside and San Bernardino are completely with us on this. We're infatuated with a piece of technology called customer relationship management. So this is nothing new. The private sector has been doing this forever and a day, usually in the context of Salesforce, generating sales leads. But the idea is that you're going to get information about a person, and you're going to start to build a relationship with them. And the relationship is predominantly electronically based, right? So I'm going to have information about you. You're going to register. So if you move to the next step, we're going to carry your information forward to pre-populate forms for you and things like that. But it also can be used to say, hey, we have a workshop that's available for this particular topic. Would you like to schedule an appointment on it? And they say, yes, they do. They click a button, they're added to the workshop, and 5 days before the workshop happens, an automatic email notification goes out and notifies them that there's a workshop there. Can you please confirm your attendance so that we can reserve your spot for you? Things like that, right? The systems can do all of this stuff, right? It doesn't require any complex coding because this type of software that exists specifically is built and tailored for these functionalities. So this notion of starting to build a relationship with your customer, which I know are both controversial terms, is really paramount to changing things from a tech enablement perspective. At some point, they may just decide, you know what, I just need more information. Right? So I'm just walking you through how we're envisioning the triage and the various protocols that Richard had defined earlier. Right? So the purpose here could be, hey, before you move to the next step, here are some resources that you might want to consider. These are the videos that are available to you. Click on any of these if you want to get more information. Again, they don't have to use this, but it's a safety net and provides comfort and context for them if they need it. And then litigant choice would be the next one. So, to see if they have a preference for, how they want to do this. Maybe they want to go to mediation first. Maybe there are other alternatives to, getting things done. And then the all-inclusive other steps, right? So where our project is right now, when we're 3 months into this project, so to the question on how long does this take, we think it's going to take 6 months start to finish for small claims. From getting the business people identified, doing the interviews, understanding how the flow and the questions might work, and getting up a first draft of it. It will not be perfect. We have no expectations of that. But we're now at the point where we're starting to identify some of these other areas. So, you get to the last step here, there's other things that you may want to do. I think the most important one is once you start to gather information and you say, oh, okay, this is actually a case that I'm mad at my employer for labor or something, you can redirect them and say, hey, it's the last stop before you file a case with the court. Maybe you need to resolve it with this other agency over here, or you have a complaint against a business and you want to do something with the Better Business Bureau, right? So there's other ways to resolve the case, but you're still directing them through a process and helping them get to an outcome in the end. So, that's what we're doing, technology-wise. Very excited about it. We think it has a lot of potential and promise. We'll know in 3 months. We'll invite Richard and Tom back to kick the tires and say, oh, my gosh, you guys really completely missed it. But we're willing to give it a shot. And so, really, from the technologist perspective, it is all about, we want to build things. We want to adhere to standards. We want to use, tools to do it. And we tend not to get distracted by things on, is it appropriate for, the court to be providing this advice, right? We just want to build things, right? You guys solve the legal implications of this, but we're going to provide you a tool set that can do it.
So, thanks, Doria and Susan, for those reactions and comments. One related thing that I want to mention is that a few months ago, and several people up here and in the room participated in this, the Legal Services Corporation at the national level held a couple of strategic summits to think about how they would apply technology to the problem of assisting self-represented litigants. And they came up with 6 strategies. And John Grecian, who's in the back of the room, was a reporter for that and organizer actually as well. So John can correct and supplement me as needed. But the reason I'm bringing this up is because one of the 6 strategies that LSC identified that they wanted to use as they pushed forward was something called a litigant portal. And I think the idea of a litigant portal is very similar to what Snorri is trying to do in Orange County, with maybe a tweak, a subtle but important tweak, even though they're leaning in this direction. And I heard several people make comments about the need to integrate this into the court processes and be careful about how it affected the way the court did this and did that. And one of the things that's a little bit of shift in thinking about the litigant portal is they take that idea very seriously, that in the first instance, the portal is from the litigant's point of view. So it sits outside the court. The court may may partner with legal services and other people in creating it, but they really want to work hard at having the portal have functions that really take the litigant's point of view and not just legal services or not just the court, all of who are maintaining separate websites right now. And I think one problem that this may help attack is an issue that Richard's pointed out in a couple of his other papers that he's written, which is the lack of coordination among organizations and resources right now in the United States in providing help to self-represented litigants. So a litigant portal would be one way of trying to improve on that situation. And one thing, really interesting development that we're following right now is that there are a couple countries who are trying to take this idea really seriously. Particularly the Netherlands has started building what I think is a true litigant portal that tries to walk them through the process from beginning to end without any presuppositions about where they would end up going or what organizations they would have to work with, and let it really be litigant driven. So that's an interesting experiment that we're watching. I don't know if you, Richard, if you have any other comments you want to make about that particular issue. If you want to use the mic.
The portal, Jeff?
Yeah, I mean, I think this issue of sort of who owns what is going to be very, very difficult. But I myself don't see a path forward without all these systems, not just about triage, but really about everything, without these systems communicating. And and sometimes, this is something I used to preach and I forgot about, and then I remembered in the context of this discussion. You know, we always say absolutely correctly, you know, the problems aren't technological, they're political, right? In however big the P is. But sometimes there's a technological fix to a political problem. And when we are dead-ended because of a political problem like confidentiality or who owns data, sometimes really trying to sort of think outside the box or use the technology, because of the fact that technology gives you so much control over what you do, that areas of uncertainty can be defined. And let me tell you a bit of a story, if that's okay, because it's very powerful, I think, which is in New York City in the mid-90s, there was a process going on to try and get comprehensive sharing of data between criminal justice agencies. And the cops would say, it was actually hysterical to be in the room, the cops would say, there's no way we can share data with the DAs because they're going to betray our confidential informants and they'll get killed. And the DAs would say, there's no way we can share our data with the cops because they'll share information about confidential informants and they'll get killed. So this is before you even talk about legal aid, right? And what we came up with was a concept in which, and remember this was actually pretty much before the internet, it's just around the same time. We came up with a system in which every data would be entered, you know, and shared with about 10 agencies. Every field carried within every transmission the authorization as to which agencies could get that field, right? Sort of like email, right? And the sending agency always had the ability to go and change their authorizations at any time. That gave them the political cover to go ahead and deploy the system. Would the DAs really turn off information to the cops? Absolutely not. The whole system would collapse, right? But it just gave people the political cover to move forward. And you know, literally millions of records were moving every year through this system. A lot of people arrested in New York, and you know, I don't know how many dollars were saved. You know, now it's very simple, but I tell the story to remember it because. And so as we think about the question of who controls data, who owns it, who puts it in,
we need to be explicit about what the worries are and try and identify, sort of rule-based solutions. Because my guess is that when you actually this is a case where being in the weeds is easier than not. Because when you're actually in the weeds, you just figure out what rules you want to put in place, and you put them in place. Whereas when you talk about it as a general problem, everybody gets terribly anxious.
Okay. Pam Casey has raised her hand. Pam, stand up for a minute. I wanted to mention, I'm glad she raised her hand, because I wanted to mention Pam because she's got a resource center and some TA resources. Pam?
Yeah, I just wanted to let you know that the Public Welfare Foundation has provided the National Center for State Courts with a grant, and we have a website. It's the Center for Court Access to Justice for All, which is a long name, but basically if you go to the ncsc.org site and put /ATJ for Access to Justice, you'll get right to our website. We have technical assistance funding. Now, it's not a huge amount. You can't come in and we'll do a whole project for you. But if you want access to some of these experts, or if you would want to go and visit, say, what's going on in Orange County, or talk to one of the folks here at the table, you can request that assistance from the Access to Justice project. So there's a tab on there. It says Assistance. All you do is click on it, and then you send in a request and ask for that kind of assistance.
Thank you, Pam. We've got a few minutes left, so let me open it up to any questions or comments from the audience. Oh, Susan has a comment. Okay, not from the audience then.
I was just wanting to make a comment in response to Snorri's presentation. I think one of the biggest challenges with all of this is how do you provide the information in a way that people can grasp and understand. And I think that's true not only for the litigant portal, but also for the judge. I mean, if your case assignment in family court, for example, is that the first case comes in, goes to Judge A, then Judge B, then Judge C, then Judge D. They're all having to do this case management and differentiation on their own, and so it becomes a bigger challenge to educate everybody about what are the things that would trigger the case to be referred to different resources. So again, if there were some kind of a technology solution where the judge could be guided along and then be told, oh, here's the latest resource. So I don't have to keep thinking about, is the volunteer lawyers program still providing this service? But it's all updated in there so that they could use that as a guide. That would be extremely helpful. And the same for legal services, to have those kinds of tools. Any of you who have worked on websites to provide public information know what a challenge it is to make it in a way that people will actually read it, and that it's not just text that goes on and on and on. And the technology solutions can do that by giving you little bits and then guiding you just to what you need. And I heard recently a presentation from a legal aid attorney from British Columbia who came up with this concept with their legal materials of a bite, a snack, and a full meal. And they were trying to have the first pages be the bite. And he was having a lot of arguments with other lawyers who said, well, you can't scale it down to the bite because all this other information is so important. And he said, well, fine, we'll put that other information in the snack and the full meal, but if people aren't reading it anyway, what's the point? If seeing this turns them off so much that they don't get any of it, figuring out what is your bite is more critical. And I think that's kind of what these technology solutions can do for us too. So we need more people like Snorri to help us with that.
So, Susan, I'm intrigued by that first comment you made about helping the judges, because all modern case management systems can be programmed for kind of event-triggered actions, which sounds like what you're talking about. So you could certainly program the case management system so when certain events occurred, it automatically suggested to the judge that they might want to do this or look at that. So That's certainly in the realm of the doable. I see Snorri nodding his head, so I think he agrees. An interesting concept.
Can I add a slightly different point?
Quickly, yep.
Yeah. And that is, we really haven't talked about the importance of research in this process. We've assumed that these protocols are being developed essentially through Delphi systems, through experts saying what they think. But those systems have to be tested, you know, and the randomization approach would be to put half of cases through a triage system and half through the old system and compare the outcomes. And ultimately, the algorithms have to be tested and improved, and we have to figure out the ways to use outcome data against those systems so that we continually improve them and identify classes of cases where we're not getting the results we need.
Okay. Well, this is really the first time that we've exposed these ideas in a public forum, so we want to thank you for being a great audience. Thanks.